The importance of religion in the American founding has provided scholars with nearly unlimited fodder for scholarly research and debate. The role of religion in the advent of the American Revolution, the faiths of the founders, and the religious influence on the Constitution and Bill of Rights has created a vast historiography that spans decades. One of the more contentious issues is religious liberty and the separation of church and state, topics that historians, jurists, and legal scholars have written about for decades. The impetus for much of the debate regarding church-state separation was the 1947 Supreme Court Everson versus Board of Education decision. Justice Hugo Black's majority opinion that referred to President Thomas Jefferson's 1802 letter to the Danbury Baptists created a firestorm of controversy regarding the definition of an establishment of religion and the original intent of the founders. The literature regarding separation of church and state has traditionally been divided into two historiographical positions that rely on different interpretations of the word separation. Separationists claim that the original intent of the framers was for the government to have no say in religion in any respect, and that the government should neither advocate for religious belief nor support it in any way. They assert that any attempt by the government to make any overture toward a religious institution is prohibited by the Constitution. On the other hand, accommodationists claim that separation, in the views of the architects of the American Republic, simply meant that the First Amendment's Establishment Clause prevented the government from establishing a national church. This intentional disestablishment did not go so far as to prevent the government from advocating religious ideas and morality. It merely prevented the church and the state from overstepping their authority in legislative and theological matters. There is a tie that binds the work of many scholars of church-state relations together. It is simply their overwhelming focus on Jefferson and Madison as the primary sources regarding intent regarding the Establishment Clause. By virtue of their authorship of significant founding documents and statements on religion and civil government, Jefferson and Madison are prevalent in the historiography of church-state relations. There are, however, others who may be counted among the founders that should be equally considered because of their influence and constant presence at the founding and in the First Congress. Though original intent and the importance of Jefferson and Madison to the separation of church and state are key points of study, the role of the First Congress and the passage of the First Amendment cannot be ignored. The legislative history of the Bill of Rights has received far less attention than other topics related to larger constitutional issues, but still provides some insight into the men who served in the First Congress. Although there are some significant gaps in understanding who these founding fathers were. The debates regarding separation of church and state involve scholars from a variety of fields. Legal and judicial historians have discussed original intent and its influence on later interpretations of the Establishment Clause. Intellectual historians have argued the philosophical and theological underpinnings of church-state separation based in the ideas of the Enlightenment and evangelicalism. Historians of religion have generally sought to establish the spiritual nature of 18th century America and extrapolate from various documents an evidence of a Christian America. All these approaches have merit, and all have provided important insights into the dialogue regarding separation of church and state, and the intentions of the founders regarding it. The research undertaken by these scholars has expanded the conversation and can be applied to the study of the members of the First Congress. The debate regarding original intent must start with some foundational perceptions, but an investigation into how philosophy, law, politics, and religion may have all been motivational factors in the decision of the First Congress to pass legislation that did what no other nation on earth had ever done: prohibit the establishment of a common national religion.